So you do not agree that 18 local governments should have been annulled?
Absolutely not. Absolutely not.
In your opinion,
yes,
the evidence of 4, because you only say that only 4 witnesses,
yes,
based on the evidence of 4 witnesses,
yes,
18 local governments were annulled. Are you saying that even the documentary evidence provided did not support their case in that particular area?
At all, at all. They didn't even provide any evidence in respect of that, apart from the card reader printer, which was thrown out.
So what were they doing all the time in the court?
That's the question that everybody would need to ask them. You see, the petitioners premised their case solely on the card reader printout. And once that was removed from the foundation of their case, the case collapsed. It had no other option than to collapse.
So are you then also saying that the tribunal did not quite know? Because if in many cases the tribunal agreed with your party in your favor that certain things should be thrown out or certain things should be discountenanced, are you then saying that they too did not quite realize what they were doing when they annulled elections in 18 local governments?
You see, that is why I started by saying it's not very appropriate criticizing or making adverse comments on the efforts of their lordships. But one thing is very clear. Their lordships are human beings, and they are capable of going wrong. The contents of the judgment, from the beginning, I can tell you that judgment is a judgment of 157 pages. It was read for about 5 hours.
7 hours, I think.
About 7 hours. It was actually, we had rulings that took off from 10 minutes to 11 and ended at 12:40. But the main judgment commenced at 12:40 and ended at 5:05 p.m. Now, in the whole process of reading the judgment, which I would draw attention to specific paragraphs of it, the tribunal did very well. They articulated the issues very clearly. They held very clearly. But at the tail end, just like in any other human being, I think there was just a miscomprehension by their lordship, with all due respect to them, of how the matter should land when it relates to the issue of disenfranchisement of voters, which came at page 146 of the judgment. The court now said, what bothers us is the disenfranchisement of voters. And they now brought up the specific issues of those who were disenfranchised. PW1 said he was disenfranchised in his unit. Another witness from Ona local government also said he was disenfranchised from his unit. Now, those are 2 witnesses from Ona local government. Ona local government has 40-something units. And we also call witnesses who testify that they also voted in these same local governments, and their evidence were not impeached or in any way discredited. What we think is that even if the tribunal were to accept the evidence of those who said they were disenfranchised in their units, the tribunal should have only nullified those specific units, and not to use the evidence of just those witnesses to nullify an entire local government.
You know, good thing you were there. You just said that there was this logical progression from the start.
Yes.
And it got to a point, it was a bit twisted. Let's talk about the veering off, getting into another trajectory. What did you see? Because if you said it was making sense until it got to that conclusion, what went down? What were you expecting? What didn't add up?
What didn't add up is that at the point the judgment got to the level before this new angle, this disconnect came up, we were just expecting a dismissal of the petition. And even everybody, both lawyers and non-lawyers, saw the way the judgment was going. And everybody was quite happy that it was going to end very well. But unfortunately, it didn't end that way. And we are not taking it up against their lordships. They are human beings. You see, in Justice Okuta of blessed memory, when he was in the Supreme Court, said the Supreme Court is final, is not final because it's infallible. It's infallible because it's final. What that means is that they are capable of committing errors, and their lordships, that is why their lordships were humble enough to tell everybody, say, we are human beings. If we have erred, this judgment is open to appeal, and that is the option we are taking. We encourage, it's good that given the industry they put in, a lot of what they raised, which are part of the principles of law established in Nigeria, are going to be fortified and solidified when we go upstairs.
Are you amazed that the APC is also going to appeal this because they feel that the governor shouldn't have been in office?
Is it no, that the government should not be in office based on the judgment?
Based on the judgment.
No, they just need to go and read section 143 of the Electoral Act. Section 143 is very clear on that. It's not something that is left to their thinking or our thinking. Section 143 of the Electoral Act says that where from an election a person who was declared the winner is sworn into office and litigations commence out of it, until that litigation gets to the very tail end of it, including appeals, the person will remain in office.
Oh, they agree with that. They're
Yes.
simply saying that, because they believe that 18 out of 31 local governments should constitute non-compliance or, substantial non-compliance, that the matter should have been nullified.
Pending the determination of the case.
No, it can't be. Because the law says through the process until the entire process of litigation, including the final appeal, which will go up to the Supreme Court.
No, what I'm saying is, we put that question to them.
Yes.
The lawyer agreed that because if this case is going to be in the Court of Appeal, he will still remain governor. They
Yes.
agreed with that. Well, I'm simply saying that they say that 18 out of 31 should be enough grounds to constitute substantial non-compliance. Do you agree?
No. You see even the 18 they are talking about,
Yes.
even the 18 they are talking about, the question is, how did the 18 even come up? That's the bottom line. It's not just like 18 should
No,
be...
isn't the
ground for
how
non-
taken care of by the judgment itself?
No. You see, the question is this. The court nullified 18 and upheld election in 13. That is part of what I said earlier. You do not use one event in one location to justify the other. The court found that in these 13 local governments, election took place well and in line with what it ought to be. But in the other part, it couldn't have been. And so the court said, well, that's how far it can go. But you see, there's some intriguing thing about what happened before the judgment. I don't know whether you are aware that the APC appeared to have known the judgment before they came to court that day. If you read page 8 of the Nation newspaper of that day, the APC had already published the result of the judgment.
That was a serious one. But Uwemoko is Attorney General of Akwa Ibom State. Thank you very much for coming on this morning.
Thank you very much.
We will be back in just a moment. Don't go away.